Good afternoon. I'm Dean Jessica Berg, and I'd like to welcome you to our Sumner Canary lecture, one of the law school's premier endowed lectures, which brings extraordinary jurists to the school to discuss current legal issues. The lecture series was established to honor the memory of the late Judge Sumner Canary, who's a judge on the Ohio Court of Appeals for the 8th District, U.S. Attorney for the Northern District of Ohio, and a 1927 graduate of this law school. The lecture is made possible through the generosity of his widow, Nancy Halliday Canary, who unfortunately could not join us here today. I do want to draw your attention to our new memorial plaque recognizing Judge Canary and listing the distinguished speakers currently on display in the lower rotunda. We are very honored today to have the Honorable Neomi Rao, a judge on the United States Court of Appeals for the D.C. Circuit, here to give the Canary lecture. One of our most cited and well-known chaired professors, Jonathan Adler, who's the director of our Burke Environmental Law Center and the organizer of this event, will tell you some more about the judge in his introduction.
Thank you, Dean Berg, and thank all of you for coming today. It's certainly a pleasure to be here. It's really one of the greatest joys of my job to be able to curate this lecture series and to be able to introduce to you people like our guest today. The Honorable Neomi Rao, as Dean Berg mentioned, is currently serving as a judge on the U.S. Court of Appeals for the D.C. Circuit, which has a special place in my heart, not only because it is the locus of so much administrative law, which I try to convince my students with some success and my family with less success is really the most exciting area of law and one that people should really want to focus on and devote their time to. But it is also a court that I clerked on myself some time ago. It's a particular honor to be able to introduce Judge Rao to you today because of the breadth of experience and the career she has had as a lawyer, as an academic, and as a public servant. Prior to joining the U.S. Court of Appeals for the D.C. Circuit, she held the job that we often refer to as regulatory czar, or in her case, regulatory czarina, as the administrator of the Office of Information and Regulatory Affairs in the White House Office of Management and Budget. The job is responsible for overseeing the regulatory activities of all of the federal agencies in our federal government. She's also worked in the White House counsel's office, as a staff attorney on the Senate Judiciary Committee, as a lawyer in private practice doing international arbitration, and as a tenured professor of law at the George Mason University Antonin Scalia Law School, where she was the founding director of the Boyd and Gray Center for the Study of the Administrative State. As a scholar, her work spanned questions of administrative law and constitutional law, questions like the role of the Appointments Clause and the removal power, to the role of notions like dignity in questions of constitutional import. Really a wide-ranging academic career that is now being capped off by time on the federal bench. You didn't come here to listen to me, so without any further ado, it really gives me a pleasure and an honor to be able to turn the podium over to Judge Rao.
Well, thank you so much to Case Western Law School for inviting me to deliver the Canary Lecture. And thank you to Dean Berg and to Professor Adler for their very warm welcome. It's really a pleasure to be here to deliver this lecture commemorating Judge Canary, a lecture that has been previously given by many esteemed colleagues of mine on the bench, as well as professors and those in public service. So my lecture today is about textualism's political morality. Let me just begin with a little parable, courtesy of David Foster Wallace. So there are two young fish swimming along, and they run into an older fish who says, "Hey boys, how's the water?" The two young fish swim along for a bit, and one turns to the other and says, "What the heck is water?" So today, what I'd like to talk about is the water that textualists swim in, perhaps unconsciously. Specifically, my lecture will explore the political morality that undergirds and informs a textualist approach to statutory interpretation. I'll endeavor to explain why formal approaches to legal interpretation, such as textualism, are an outgrowth of political morality and carry political morality into practice. This way of thinking about textualism may seem surprising. After all, textualism is a kind of formalism. It draws a sharp line between the law's objective meaning and the judge's subjective moral preferences. Textualists hold fast to the principle that the law is the words enacted by the people's democratically elected representatives. It follows that in deciding individual cases, judges must give effect to the law as it is, not as they believe it should be. The textualist approach is therefore frequently juxtaposed to methods of interpretation that rely on the judge's abstract normative values about justice or fairness, or approaches that seek to update statutes in accordance with evolving social or political norms. I'm wholeheartedly on the textualist side of these debates. But the familiar defense of textualism sells it short. So what this lecture aims to do is identify the rich moral foundations of a text-based approach to interpreting statutes. I'm leaving constitutional interpretation for another day. And I want to make two basic points. First, I want to defend textualism from the vantage point of political morality. Properly understood, textualism follows naturally from the moral commitments that stand at the heart of our constitutional system of government. Understanding textualism from this perspective is especially timely in light of recent criticisms of formal text-based methods of interpretation. For instance, a wave of post-liberal scholars, such as Adrian Vermeule, have suggested that laws should be interpreted to promote what they call the common good. They claim textualism is inadequate because it is indifferent to the common good. But this isn't really a new criticism. Rather, it merely taps into some dominant critiques that when interpreting legal text, judges should give effect to certain substantive values, values that exist independently of the law. There are many variants, but to name just a few, Ronald Dworkin argued that judges should act as philosophers, promoting justice, understood in an abstract way. Bill Eskridge has argued that statutes must be interpreted dynamically in light of contemporary social and moral norms, and Judge Posner maintained that judges must interpret statutes pragmatically to promote efficient outcomes. In short, the critics of textualism, past and present, disagree about the right yardstick, but they all argue that judges should interpret statutes in light of principles found outside the law. They maintain that such principles will tend to lead to better results than simply following the text of the law. But textualism isn't empty of moral content, as some of its critics would suggest. Rather, textualism is rooted in a distinctive moral commitment, a commitment enshrined in our Constitution to be governed by positive laws, namely the Constitution and the statutes enacted by the people's representatives. We live under the rule of law, not the rule of men, and the Constitution is the result of a reasoned, moral choice that a society governed by law is best for social flourishing and worth defending. My second point is that our statutes are enacted within a legal tradition that subsumes political morality. Our mature and sophisticated legal tradition is built on principles of natural law, common law, even stretching back to the Roman law. In determining the meaning of a statute, textualists may rightly turn to these legal sources for guidance. Interpreting the laws within our legal context is part of exercising the article-free judicial power. So seen in this way, textualists aren't indifferent to political morality and interpretation. They simply recognize that our legal tradition has translated and disciplined principles of political morality into postulates of law. A faithful textualist, then, must grapple not only with the words on the page, but also the meaning of those words in the context of our traditions. So those are my two basic points. Fidelity to positive law is itself a profound moral choice, one that Americans made when ratifying the Constitution. And textualism, properly understood, invariably draws in basic principles of justice and morality that are baked into our legal foundations. Let me begin, then, by discussing the moral choice at the root of establishing a system of binding positive law. Perhaps it will seem puzzling and counterintuitive to say that textualism has its own political morality. Textualists rightly seek to separate legal interpretation, both from partisan political concerns and from the demands of morality or justice abstractly understood. And critics of textualism and other formal methods of interpretation often emphasize that the outcomes of text-based interpretation can be unjust, unfair, inefficient, immoral. And non-textualists frequently propose that when interpreting statutes, judges must apply some non-legal yardstick. On this view, judges should cite those values to correct the results of an exclusively text-based interpretation. Because textualism separates law from these abstract values, it is sometimes labeled as amoral or even immoral. Textualism, however, rests on a moral foundation. Focusing on the enacted law is not moral indifference, but rather respect for a prior moral decision about how to resolve the inevitable disagreements about the content of the moral law and how it should be applied in a specific case. In other words, the moral foundation of textualism is rooted in natural law ideas about reason, justice, and the good. Let me explain briefly what I mean by this. So Philip Hamburger, professor at Columbia Law School, details this history with great learning in his book, Law and Judicial Duty, and I draw from his account here. So basically, at bottom, human society faces a fundamental problem. There are many good faith disagreements about what justice requires in a particular case. The establishment of lawmaking authority and the creation of the positive law provides a solution to that fundamental problem. As Professor Hamburger has explained, earlier justifications for obeying the law depended on believing that the law coincided with God's will or with the natural law itself. But of course, there are often disagreements and confusion about what the natural law or the common good requires in general, and especially in particular cases. To take Aquinas' example, what punishment does natural law require for a given crime? There's no single answer to such a question. And all of the major natural law theorists recognize this problem in some form. So even if we were all Catholics or libertarians or utilitarians or Marxist revolutionaries, such that we agreed on first principles, we would still inevitably disagree about how those principles cash out in any given case. Human reason is limited. Human beings are flawed. A functioning political society, therefore, needs rules that everyone agrees are binding. So the solution that people came up with over time was to choose a sovereign lawmaking authority that would translate the natural law into binding laws. And the justification for that authority was not that it would always choose the right answer, but that it would be a lawful authority to settle disputes. Because individuals frequently disagreed about what was good, a government with lawmaking authority would channel disputes about the common good into debates about legislation. The existence of such an authority would be most conducive to promoting peace, order, and stability. Viewed in this light, the decision to adopt a system of positive law made a good deal of sense as a moral matter. And so the point of this highly condensed history is that legal doctrines don't displace morality, they implement morality. At bottom, the establishment of the positive law originates in a moral decision by the people. It's part of a reasoned choice to promote a peaceful and free society by resolving disputes through the enactment of law rather than through abstract moral debate. More specifically, in the United States, our constitutional government is an attempt, a uniquely successful attempt, to establish a political and legal authority in the face of imperfect human knowledge and reason. As the preamble to the Constitution states, the people adopted the Constitution to establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity. Our founding fathers separated law from moral philosophy precisely in order to establish a just and good society committed to the well-being and safety of its people. So, what does all of this have to do with textualism? Textualism, in my view, is a natural and perhaps a necessary corollary to our constitutional decision to create a system of formal law and to vest judges with the Article III judicial power. It may be helpful here to just summarize some of the basic tenets at the heart of textualism. First, there's a constitutional foundation. The statutes that bind society must be enacted through the Constitution's exclusive process of bicameralism and presentment. Second, it follows from this constitutional requirement that judges must follow the plain meaning of the enacted words. The interpretation of the statute doesn't turn on the intentions of lawmakers or the favored policies of the day or the judge's beliefs about social justice or morality. None of these intentions or beliefs went through the constitutional process for enacting law. In practice, this means a judge must focus on the text of the statute to determine its meaning. And third, the rule of law requires a law of rules, rules that are impartially adjudicated by neutral decision makers. Law does not include arbitrary decrees from the executive branch or lawmaking from the bench. The proponents of textualism have endeavored, I think quite properly, to emphasize the limits on judicial discretion. In a democratic society, text-based interpretation is a distinct enterprise, separate from abstract moral, philosophical, or theological inquiry. And since we are all apparently textualists now, as Justice Kagan has said, I think these arguments have become relatively familiar. Nonetheless, the political morality of textualism is often obscure, but I think we should look at it more closely. Textualism is arguably the most legitimate mode of interpretation in a society that has made the choice to live under the enacted law. As a method of interpretation, textualism actively reinforces the initial choice of the American people to distinguish law from other human inquiries like moral philosophy. That choice to create a separate domain of law is rooted in natural law and reason, and it reflects the conclusion that a peaceful, prosperous, and free society will establish law as a separate authority over the people. So next I want to explore a bit how the positive law incorporates legal principles and legal methods that have developed over time. These principles and methods reflect basic moral commitments and reasons. In the United States, we enjoy a highly advanced and developed legal system, and Congress doesn't enact statutes in a vacuum. Lawmakers act within our particular legal context. Indeed, it would be impossible to write an effective statute that could be interpreted only by reference to Webster's Third Dictionary. Every statute enacted through the constitutional process is rooted in this distinct legal history and tradition. And that tradition, in turn, has been shaped by and is an expression of certain fundamental moral commitments. Judges vested with the judicial power may rightly rely on this legal tradition when construing the text of statutes. To be clear, these legal foundations that I'm talking about that inform the meaning of statutes must be postulates of law. They do not include abstract moral principles or policy preferences, nor do they include the intent of the lawmakers, the spirit of the statute, or the personal preferences of the judge. As Justice Scalia once explained, to be a textualist in good standing, one needn't be too dull to perceive the broader social purposes a statute is designed to serve, or too hidebound to realize that new times require new laws. One need only hold the belief that judges have no authority to pursue these broader purposes or write those new laws. So in a constitutional democracy, the legislators write the laws. And the judges interpreting those laws cannot reach for external values of justice and the common good. But in deciding cases, judges can, and perhaps must, consider interpretive resources internal to the law. And this might all sound highly abstract, but I assure you it's not. The legal foundations I have in mind are quite specific, and I think their range is manageably bounded by historical considerations. I think some examples may help to mark out this limited province of the law. So first, judges rely on constitutional principles. The Constitution's text and structure establish the social compact that forms what Professor Stephen Sachs has called the backdrop of all other enacted law. The supreme law of the land incorporates choices about what type of government will be most conducive to a free and flourishing political community. And by establishing popular sovereignty, separating the powers of government, and making laws difficult to enact, the Constitution protects individual liberty. As James Madison said, the preservation of liberty requires that the three great departments of power should be separate and distinct. So our laws necessarily must be interpreted within this constitutional framework. For example, statutes are interpreted when fairly possible to avoid an inconsistency with the Constitution. Various principles of interpretation reinforce constitutional requirements, such as the vesting of all legislative power in Congress. For example, sometimes the Supreme Court assumes that Congress doesn't hide elephants in mouse holes. This means that major policy questions must be decided by the people's representatives, and that such questions cannot be implicitly delegated to administrative agencies within the executive branch. The Supreme Court applied the major question doctrine, for instance, when concluding that the Centers for Disease Control lacked the authority to issue a nationwide eviction moratorium. Because Congress had not clearly granted such authority to the CDC couldn't rely on a decades-old statute to grab such unprecedented and sweeping power to act on a matter of vast economic and political significance. Similarly, the vesting of all executive power in the president has important consequences for how far Congress may insulate administrative agencies from presidential control. In a recent decision involving the Consumer Financial Protection Bureau, the Supreme Court indicated substantial limits on such agency independence. As the court explained, the president cannot delegate ultimate responsibility or the active obligation to supervise that goes with it, because Article 2 makes a single president responsible for the actions of the executive branch. So the president must supervise the execution of the laws, even over the so-called independent agencies. And the reasons for this stem from the Constitution's creation of a unitary executive, designed to promote democratic accountability and limit government overreach. As Chief Justice Roberts explained, the framers recognized that in the long term, structural protections against abuse of power were critical to preserving liberty. So interpreting statutes in light of constitutional principles furthers the political and moral choices made in the establishment of our constitutional form of government. Those values include protections for individual liberty, limitations on government power, and the importance of representative government in making decisions for the good of society. Another background source of legal meaning is the common law. Many of our legal principles, as well as our statutes, have common law roots and are enacted against a common law baseline. Statutes will sometimes use a legal term without defining it because the term carries with it a developed meaning from the common law. As Justice Frankfurter noted, if a word is obviously transplanted from another legal source, it brings the old soil with it. We often see this in criminal law because statutes codify common law crimes. We know that a statute that punishes the reckless destruction of another's property requires a different mens rea, or mental state, than one punishing the negligent destruction of property, because both of those concepts, recklessness and negligence, have deep common law roots. Other statutes incorporate common law concepts to deal with modern problems. So consider the case of Babbitt versus Sweet Home. The question was whether modifying an endangered species habitat was a prohibited taking of a species. The majority relied on the Endangered Species Act broad purposes of protecting wildlife. Because the statute defined take to include the word harm, the majority found that the habitat damage could be a taking. After all, you harm an animal, quite literally speaking, when you hurt its habitat. Justice Scalia dissented, and he emphasized, correctly in my view, that the act criminalized taking an animal. And the phrase taking an animal has a long common law history, going all the way back to the Roman law. One can only take an animal through intentional action directed against that particular animal. Damaging an animal's habitat simply wasn't enough. Congress, of course, may choose to override the common law in a particular statute, but when the common law term has been enacted without modification or further definition, judges typically fall back on common law principles to interpret the statute. Another example stems from a recent case I decided involving Indian law. The statute directed the government to take into trust lands acquired by the Sault Ste. Marie tribe. In resolving the case, we reasoned that because the statute imposes a trust responsibility for the government, background principles from the common law of trusts may inform our interpretation. And in common law, a trustee couldn't manage illegally acquired property or establish a trust contrary to public policy. And those common law concepts were essential to the ultimate interpretation of the statute. In addition to the constitutional and common law foundations, there are many general legal principles and background understandings that also inform the interpretation of statutes. I think these are increasingly less familiar to lawyers and to judges. There was a time when the legal profession studied and were steeped in certain basic concepts about the law. Those concepts didn't necessarily need to be specified in cases because they were simply taken for granted, sort of like water for the fish. So what's included within these general legal principles and background understandings? Again, I think some examples might help make this a bit more concrete. So consider, for example, the venerable concept of due process of law. Due process of law is, of course, protected by the Constitution. And the meaning of due process, though, incorporates a long history of working out what process is due. For instance, due process usually includes, we say, notice and an opportunity for a hearing. The Supreme Court has also recognized that due process varies by the particular context and the rights that are at stake, that it requires balancing the government's interests with the individual's interests and rights. We see the executive branch of the courts face questions about due process in many different contexts. The Department of Justice's Office of Legal Counsel issued a long opinion about what process is due to a U.S. citizen who is targeted in a drone strike. The full D.C. Circuit recently heard a due process challenge from a detainee held at Guantanamo Bay. More prosaic, but no less important to the people who are affected, by this, my court frequently hears challenges to the process afforded by administrative agency proceedings. The rule of lenity is another background principle and one closely related to due process. When a criminal statute is ambiguous, the rule of lenity counsels the judge to adopt the construction that is more lenient to the criminal defendant. In Staples versus United States, for example, Justice Thomas, writing for the majority, explained that when a statute is silent as to the requisite mens rea, the rule of lenity requires the court to defer to the long-standing presumption that the law doesn't punish those who have no intent to commit a crime. The decision drew on lenity and background principles of English and American common law, criminal law, reaching back to the English common law. The rule of lenity is really a quintessential example of a moral political norm that has been distilled into a kind of legal maxim. Lenity creates a presumption in favor of individual liberty, ensuring that the government cannot convict a person unless the law provides clear notice of what actions are prohibited. Other background principles arise from the fact that judicial decisions also give a reason for their judgment. They provide principles to govern future cases. Chief Justice Marshall spoke about the peculiar province of the judge to say what the law is. And when judges say what the law is, they provide reasons for their interpretations of the law. Although such reasons are not part of the enacted law, they invariably become a part of our legal system and shape how we interpret the law in the future. Background principles of law also include certain axioms of reason. Hadley-Arkes, for instance, has identified several such axioms in the writings of Chief Justice Marshall and Joseph Story. I agree that the law and legal interpretations incorporate certain reasons. I don't think those are abstract moral reasons, but they are reasons inherent to what we mean when we talk about law. So, for example, Justice Marshall has argued in McCulloch that the power to make binding law entails the power to punish violations of that law. Justice Story reasoned that if a government cannot do something directly, it cannot do it indirectly either. These are just general principles of reason that stem from the nature of what it means to have binding law. Another background principle is the reason of the laws, plural. As a judge, I find that interpreting the words of a statute often requires understanding the statute in the context of our other laws. Justice Scalia referred to this as judicial rationalization, by which he meant that judges interpret various laws as a coherent whole even if lawmakers don't always in practice seek out such coherence. One way judges do this is by applying the whole code canon, which favors interpreting statutes to fit within the context of other laws. This presumption drove the Supreme Court's decision in the Brown and Williamson case, which held that the Food and Drug Administration lacked the power to regulate cigarettes. Looking only to the text of the statute, one might have concluded that the FDA could regulate cigarettes because nicotine literally fit within the statutory definition of a drug. Justice Breyer made this argument in dissent. But the majority, joined by Justice Scalia, properly considered all of the different statutes Congress had enacted that specifically regulated tobacco, and found that those laws were incompatible with letting the FDA regulate cigarettes. So the court the dissenters looked at the legislative landscape, the whole code, and thought that that was what mattered for finding the best and most rational interpretation of the statute. So these are just a few examples of how statutes rest on deep foundations shaped by constitutional law, the common law, and background legal principles. These traditional sources of legal meaning in turn incorporate and reflect moral values drawn in from the natural law and the reasoned working through of legal principles within our particular legal culture. And I hope that it's clear from these examples that what I'm calling fundamental legal principles and traditions are different in a meaningful way from Dworkinian justice or the pursuit of an abstract moral good. These principles aren't plucked from the air, nor are they found in the heart of the judge, but they are assumptions and principles integral to the distinct province of the law. And a faithful textualist should interpret statutes in light of these foundations. Let me bring this lecture to a close with some final thoughts before opening it up for your questions. This lecture, and I hope to have a published paper expounding on some of these things a little bit more, this lecture was really motivated by my experience on the bench over the past few years. A significant number of the cases I've decided turn on questions of statutory interpretation. Now, some cases are relatively easy because the words of the statute have a readily discernible meaning. In others, however, the right interpretation doesn't immediately spring up from the words of a page. Rather, judgment must be exercised to determine the meaning of the law. And that judgment has to focus on the text and structure of the statute, but it also includes understanding the meaning of the statutory terms in a wider legal context as rooted in the soil of our legal traditions and practices. In taking this approach, the textualist judge respects the political morality of our constitutional form of government. Identifying the broader legal principles at work in statutes, whether they're derived from the Constitution or the common law or other background legal concepts, isn't an abstract search for the moral good. Rather, the textualist draws from our distinct and rich legal culture, which has incorporated particular principles of reason, justice, and political morality. And I recognize that perhaps there's some danger in emphasizing textualism's political morality. Critics may claim that legal foundations are just another way for judges to impose their personal preferences and values. Justice Scalia, our public textualist #1, rightly emphasized curbing judicial discretion. He didn't focus on political morality per se, but if you read his opinions, he very much practiced this in his writings and his decision-making. His interpretation of statutes masterfully wove in background principles, including those drawn from the constitutional structure and the common law. So I think there are advantages in demonstrating and explaining and developing the particular political morality of formal methods of interpretation, such as textualism. And that advantage comes from showing that textualism isn't amoral or dull or disconnected from the foundational truths of reason and justice. I think it's both true and humbling that judging requires the exercise of judgment, the particular type of judgment required by and inherent in the Article 3 judicial power. Textualism, in my view, emphasizes the right type of judgment and the right type of reasons to apply when interpreting statutes within our constitutional form of government. Thank you so much for your kind attention. I welcome your questions.
Thank you, Judge Rao, for that. We do have some time for questions. There is a microphone, so if you have a question, please raise your hand and I will direct the microphone to you. Please wait for the microphone to reach you so that for purposes of the recording you can hear the question. And I will steal the moderator's prerogative to ask the first question. It seems that one possible objection to this formulation might be that at the broad level of generality that you define textualism would enable a judge to look at a particular case that might produce what the judge considers to be a completely unbelievable outcome. And to say that, well, this text was enacted, again, within certain assumptions about legal principles, about what sorts of things would operate that weren't stated because, like the fish, we're in the water, we don't go to the water, we didn't feel the need to state it. And I am being a true textualist by adopting an aggressive absurd results doctrine, and I'm wondering how you would respond to that sort of stuff.
About absurd results.
Well, as being consistent with textualism as the way you've defined it is sufficiently capacious to allow for a fairly aggressive absurd results, arguing that it's basically grounded in these same fundamental principles that you think are operating.
Yeah, so I think, I guess the first, so in emphasize, I guess I'll say by emphasizing the political morality of textualism, I don't mean to throw out the conventional justifications for textualism. So a textualist still has to begin with the text of the statute, right? And so if the legislature has, has put forth a law and they're fairly clear about it and it leads to an absurd result, well, that's just living in a democracy. And so I don't think there's really room, in my view, for just finding something to be absurd just based on an abstract view of morality. It could be that result is just inconsistent with our understanding of the common law or of the constitutional structure or something like that. But I don't think it opens up space for kind of a general absurdity exception, precisely because we do have to look at the text and structure of the statute first and foremost.
Questions for Judge Rao?
Judge Rao, thank you. Can you hear me? Okay. Judge Rao, thank you for being here. A quick question. Does textualism provide the most faithful example of the type of judicial philosophy expressed in Federalist 78, specifically the notion that judges must not replace the judgment of the legislature with their own? And if not, what other set of principles would?
Oh, I think textualism is very much consistent with Federalist 78. Because, they say the judge must exercise judgment, not will. And I think that's a very important limitation on what judges do, right? The judges have to exercise judgment in interpreting the laws, whether the laws are the Constitution or the statutes enacted pursuant to the Constitution. But it doesn't include whatever, the judge prefers as a good outcome. So I think textualism is very much consistent with Federalist 78.
I've got to confess, looking at the term political morality, in my sense, is a bit of an oxymoron. Having seen so much sausage made in the legislative process, it seems to me that the ultimate rationale of the, quote, good of the morality is the outcome of the democratic process. But how do you deal with such legislation that may, and in fact often does, result from a fair degree of corruption or simply bad results? Take the Fugitive Slave Act, for example, which upheld notions of private property, but today most of us feel are appalling.
Sure. Well, Yeah, I mean, I guess by political morality, I mean something more akin to what is not necessarily that the outcome of the political system is moral, but that by agreeing to live under laws enacted in a certain way, there's a morality underlying that basic choice, right? When we decided that Congress can only make laws through bicameralism and presentment, that's the political moral choice there. Now, laws that are really bad, I mean, some of them may be inconsistent with the Constitution, properly understood. And then courts, of course, have the authority to say that a statute is unconstitutional. And that's one relief. And, for other laws that may at least formally be consistent with the Constitution, then, I guess we have to rely on the political process. But that's part of the choice we've made.
Questions?
You're well grounded in this material, and I and perhaps others are not. But a quick question is this. In a divided government with equal branches, where the judiciary is responsible for exercising judgment, why wouldn't that responsibility be equally grounded in political morality as you define it, since the morality is inherent in the responsibility of the judiciary to exercise its judgment?
So I guess my answer to that would be that the judges do exercise a kind of political morality, but it is a political morality bound by law. So judges don't have any authority under the Article 3 judicial power to impose their own personal views of what might be the moral good. They have to exercise judgment to understand the Constitution and the laws that are enacted by the people.
But by saying so, you have elevated one branch of government over the other. You have chosen to elevate that branch by saying that the judiciary must defer to the statement of the legislature, when in fact the moral history of the country is that the legislative branch has no ability to exercise its own judgment in applying its law. That responsibility is to the equally moral branch called the judiciary. You have imposed what you perceive to be the morality of the legislature. You have superimposed it over the morality of the judiciary.
So I think respectfully I would disagree with that characterization, or maybe I wasn't entirely clear in my lecture, but I think that there are different types of morality that are exercised by the different branches, and I do not mean to suggest that the courts should defer to Congress or to the executive about, for instance, whether a law is constitutional, right? It's our role to determine whether laws are constitutional. But we live in a constitutional system where lawmaking has been given to Congress and the president acting together. And so it is outside the scope of the judicial power, in my view, to make laws or to amend laws. I don't think that's part of the power that I was given with my commission. And so it's not so much a question of deferring to the political branches as recognizing that within our system we have different roles in implementing the political morality of the Constitution.
Right here, yes.
Judge Rao, thank you very much for coming in today. Building off the third question, sausage and all, it seems the way you're defining political morality assumes a fair, representative, democratic republic that some here today, particularly myself, may not agree has ever actually been realized, given that historically different parts of our country haven't had that fair representation, haven't been allowed to agree to this process, these laws in certain ways, or been allowed to disagree. How do you come to terms with your definition of political morality with this, I think, rather obvious truth of history?
So I guess I would say that even if that historical account is true, and that there are people who have been disenfranchised or people that are not properly represented, I'm not sure that it's the role of the courts to fix that. except if, except through, the process of judicial review and determining whether a particular statute is constitutional. I think that we live in a democracy, and if people are concerned about that, there has to be a political fix for that. I don't think we want to live in a world where judges are deciding what is the greatest good, because that might work if the judges are people that you happen to agree with, but oftentimes they will not be people that you agree with, and then there's nothing you can do about it because they serve for life and they're not democratically accountable. So I think that's it's just a limitation of what the judicial power is.
Thank you.
Would that be different? I mean, I'm thinking just from our standpoint, we're in Ohio right now, and our judges don't serve for life.
Mm-hmm.
They're kind of age limited in terms of running for re-election, and they run for election.
Mm-hmm.
Does that change it in any way, meaningful way, or no?
Yeah, I think states can establish judiciaries with different types of powers. State courts have common law powers that federal judges generally do not. And they may have a different constitutional system that gives judges more or less power than federal judges. So I think it depends on the state and the type of constitution it creates. Yeah. I'm only talking here about federal judges, obviously.
I hope this is a fair question for you, okay? Because I know your area is administrative law, but your construct for interpreting the law, is there a particular challenge to that if you're interpreting the enforcement of a treaty obligation, and specifically where there is a duty, at least under the Hague Convention on Interpreting Treaties, to interpret the treaty in a manner consistent with the interpretations of the sister signatory nations. So,
yeah, I think treaty interpretation is interesting, right? My topic here is statutes, which are a little bit different. I'm not an expert in treaty interpretation, but I tend to think of treaties as, in some ways they're contracts, right? They're two contracts between nations. They may be interpreted against other background principles of international law that may be incorporated into the treaty or not. And so I do think that can at times raise different concerns. I also think with respect to treaties, of course, there are many cases noting the particular importance of the executive branch's interpretation of a treaty, and for courts not to step on the toes of the executive branch in implementing treaty obligations because of the sensitive foreign relations issues that are at stake. So I do think treaty interpretation can raise some different issues from statutory interpretation.
I have lots more. I want to make sure. So while people think of additional questions, there we go. Yes?
Oh, hi.
Let's wait for the microphone.
Okay. Hi. So thank you so much for being here. It's very interesting to hear this. So I'm in a conflicts of law class, and one of the things that we're learning about is courts often interpret the laws of other countries and have to apply them. So if a court is applying the law of a foreign country, and would you apply a textualist approach to a foreign country's statutory law? Because in that case, the foreign country might have a different political morality than our own. So would the same principles apply, or would you use a more purposivist approach if that's what that jurisdiction uses?
Yeah, I think that's a difficult question to answer in the abstract, because I think it depends on, what context are we looking at the foreign law? Is it a contract case? Is it, like a treaty obligation or some kind of international conflicts case? So I think it would depend. Also, is there a foreign government that is involved in the case that is asserting a certain authoritative interpretation of its law? I think it's hard to say how that should work in the abstract. But I lived in England for several years, and one of the things that taught me, I learned a fair amount about English law and some international law, but what you realize living overseas is how hard it is to understand what the law means in another country. Even after being in law school and living in our system for many years, sometimes it's hard to figure out what the law means. So there are really a lot of perils in trying to understand what foreign law includes, I think.
How much of that is the fish and water problem, and how much of that is that other laws may not have been drafted with the same implicit understandings about how one codifies or concretizes legal principles and documents?
I think it's all of that, right? It's partly you just don't know what water there's there. You know, in other countries, I mean, we're often not aware of the water we're swimming in. We certainly don't, it's even harder to understand the water other lawyers are swimming in. So, yeah, I just think there's so many background things that we don't know. You know, the things that they might just assume, and we don't even know what the assumption is because it's not written down. And I think you can often make a lot of mistakes by just reading something and thinking, oh, I know what this means.
Just
a quick point about your question, which is foreign law in U.S. courts. Basically, a judge looks at foreign law as questions about foreign law are questions of fact. They're not legal questions to the U.S. judge. So you take deposition, you know, and then you will battle, you know, to get to the meaning. So statutory interpretation is not, in textualism, is not necessarily the vehicle because it becomes a question of fact. The one question I have, which is one of my favorite examples, the most famous case that law students studied in the first year, the Erie decision of 1938.
The Erie decision?
The Erie decision, where basically Justice Brandeis, among other things, reaches constitutional grounds to basically come up with the rule that there's no general federal common law. But to get there, he's interpreting the Rules of Decision Act, and he arrives at a point where he basically states that yes, the law of Pennsylvania, which is the issue in the case, everybody who's gone to law school remember that has nightmares about the Erie case probably. Everybody basically he basically states, yes, the common law of the states is a substantive law of the countries, therefore of the state, therefore should apply under the Rules of Decision Act. And he could have stopped there. I always ask my students at that point if he could have disposed of the case, Justice Brandeis, at that point. And I use that to illustrate constitutional avoidance. So my question to you goes to constitutional avoidance. You know, is constitutional avoidance another of these moral values or another of these principles that look like technical principles or formalist principles but that actually have behind them the moral respect and the deference that we have for not actually reaching questions that we judges do not need to? Thank you.
Yeah, I think there is sort of a general understanding that if it's not necessary to decide more, it's necessary not to decide more. You know, I think that is something that judges keep in mind. Constitutional avoidance can be a principle. I think that's something like that. Although, I don't know, find a constitutional avoidance case where they avoid the constitutional question and you really believe they thought it was unconstitutional, right? It's not going to happen very often. So sometimes I do think those decisions create kind of a penumbra around statutes, which is not always desirable. But I do think there are times when it isn't necessary to go further, and then judges should refrain.
Do you agree that Erie was one of those cases?
Oh, I'm not going to get into Erie. It's like a whole can of worms.
But you also, I guess, would not join Justice Kagan, who suggested an oral argument, I guess, was last week, that all substantive canons of construction should be thrown out.
Yeah, I don't think I would agree with that. I think you have to be careful with substantive canons because I don't think judges should be putting a thumb on the scale of statutes. But I do think there are some principles that are of such long-standing vintage and that sort of embody various values of our society that unless, you shouldn't interpret a statute to go against one of those principles unless it's very clearly the case that Congress chose to do that.
Well, we've reached the bottom of the hour, so please join me in thanking Judge Rao for her remarks. At a normal time, times I'd love to invite you all to a reception, but the university still doesn't let us do that. But I certainly hope you'll be back for a future Canary lecture, and I certainly hope you'll be able to treat all of you to a reception at the next such lecture. Stay well, stay safe, and thank you again all for coming.
Okay.